Welcome to Courtroom Quarterback, the experiences and thoughts of a court-martial defense attorney.
Hey everybody, welcome back to an all-new episode of Courtroom Quarterback, the experiences and thoughts of a court-martial defense attorney with attorney Joseph L. Jordan. He's the founder of the Jordan UCMJ Law Group. I am your host, Mike Leon. You know, Joseph here is a former Army JAG and worldwide court-martial defense attorney. He's tried more than 240 court-martials to verdict and handled over 350 military cases all across not only the United States, but Europe, the Pacific, and in the Middle East. In today's episode, we're going to be talking about something that can make or break a defense long before the trial even starts, and that's the people that are on the team. Joseph's going to explain how detailed defense counsel fits into a case, how the roles get assigned, and how chemistry, trust, and accountability show up when the pressure is on. Joseph, it's good to see you as always. You know, let's start here at this high level. So when a case includes a detailed defense counsel, what are you paying attention to when you first start divvying up the responsibilities?
First of all, good morning, Mike. Thanks for having me. What am I looking for? First and foremost, I pay attention to how they speak. How are they reacting to me and my questions? Are they well spoken? Do they sound confident? Those things matter. And I do that. I start that assessment through an interview process. So once I know I'm going to be working with a counsel on a court martial, we know the case is going to court or it's going to an administrative board of some sort. I interview them and I get to know them. And I first do that by disarming them, by telling them a little bit about myself, telling them about my history, where I've been, what I've done, try to be a little self-deprecating a little bit, let them know I'm human, because I am aware that some of us in this world have a reputation. And so I'll let them know who I am. And then they, in turn, tell me a little bit about themselves. I understand what their constraints are, what their weaknesses are, what their strengths are. And then we begin to break down those kind of natural walls and barriers that you have when you first meet someone, and then push that aside and get to work.
You know, when you're putting teams together and you got the 49ers stuff in the background, so you know what team chemistry looks like, right? But what are some things that tend to show you whether the defense team is going to function smoothly, especially once pressure starts building in the case?
Can you take a joke? That's the number one indicator. Can you take a joke? And this is something that I've found very true in my experience. Being able to joke, being able to be frank with individuals. You cited the 49ers. You know, George Kittle talks about how he first met Brock Purdy and, you know, how is that interaction going to go? We hung up a University of Iowa jersey in Brock Purdy's locker, and Brock Purdy went to Iowa State. How did Purdy react to that? He's like, get this crap out of my locker. That was a great indication to Kittle that this is going to be a great teammate. So when you're working through these things as a litigation team, and you know you're going to be in the battle, and you know you're going to be in the trenches, you got to be able to tell a joke. Can you take a joke? Can you receive one? And then the other thing is being frank. Can I be real with this individual? Because if that person can be real with me, whether it's male or female, heterosexual or homosexual, doesn't matter. If we can be real with each other, then we can work well together in the courtroom, period.
Well, staying with the football analogy, you got to put the players in the right positions to succeed. So with respect to the courtroom now, how do you kind of decide who handles which parts of the case? So that way the people that are, you know, they're put in their best position to succeed. They're put in the strongest lanes rather than overlapping or even getting in the way.
Well, first and foremost, people expect me to do a certain amount of things in a court. So what you can expect is I'm almost always going to select the jury, give opening argument, give closing argument, cross-examine the main government witnesses, right? But there's a lot of work that leads up to getting into the courtroom. And I always tell my co-counsel, you're not going to be a potted plant, right? You're going to have a role here. And so I ask them, you know, as we move through the process, what are you interested in? What do you like doing? What do you think you're good at? Where would you like to improve? Now, if I'm being paid to try a case, it's not my role to improve that counsel that is being paid by the United States government. That's not my job. But I do want to maximize their strengths to the client's benefit. And people are naturally drawn to things that they're interested in. So if there's an area of the case that they really want to work on, by all means, that makes us a better team. A lot of times, counsel feel that they are stronger in motions practice, and I have to make an assessment there because motions oftentimes dictate where a case is going to go. We're going to talk about that in a couple of episodes. So that's a careful analysis, but really and truly, it's assessing strengths and weaknesses, what it is they like to do, what it is that they're good at doing, and where what are the stakes, right? And how far can I trust them to do certain work? In many cases, I will do the majority of the work because that's simply what's expected, number one, and that's what's required. But at least 35% of the time, maybe a little bit more, I'll have a good co-counsel or a strong co-counsel, and we'll work well together, and they'll work in the roles that make sense to them.
Let me ask you, how do you manage as well the experience levels? Let's say you get a younger co-counsel and maybe you got to approach it with a little bit more mentorship. Like how do you manage that while still keeping the case, obviously on track?
Well, again, it's an assessment of strengths and weaknesses. And so you really have to understand what you're working with, who you're working with. And so it's a matter of asking questions. I have a great working relationship with defense teams out of Fort Hood. So I oftentimes know who the senior defense counsel is or the regional defense counsel is, and I'll get intel on the counsel there. Hey, or I'll talk to other peers. Hey, give me your thoughts on them. That gives me a kind of a read ahead on how much mentorship is going to be required, how much of the case I'm going to have to actually run, those sorts of things. But really, it's a give and a take, right? And it has to be organic. You want it to be organic. It shouldn't be forced, because if it's forced, then you're not maximizing the talent of the individual that you're working with. And that individual is not maximizing their talent. And then they're running around scared and not sure what to do. And so I set baselines. If it's a younger counsel, not very experienced, doesn't have a court martial under their belt, or maybe they've only done 2 or 3, I say, hey, look, this is how I do business. And I lay out guidelines. Okay. This is how we send emails. If a client asks you a question, we're going to talk about it, and then we're going to answer the question together, right? So we meet. I never let a young counsel meet with a client by themselves. And there's a variety of reasons for that. And if they don't make decisions, right? Unless I've given them the initiative to do so. Now, we also have to remember, their counsel, they're answerable to their own bar. And so they have their own legal opinions. But because I'm the civilian defense counsel, I'm counted as supervisory counsel. So those things have to run through me. And everybody understands that. They know the rules when they're working through that. But sometimes you're working with counsel that's more experienced, and they've tried 20, 30, 40 cases. They've got a good sense for the jurisdiction that we're operating in. They know the judge, those sorts of things. Then maybe I can give them a little bit more rope. Why do I do that? Because it's benefiting the client. And that's what this all comes down to. What is in the best interest of the client?
Well, let's get into the friction part of this. So somebody isn't contributing the way you need them to do it. How within there do you maneuver? Do you adjust roles? Do you, meet the challenge head on without letting obviously any ego or friction last that could affect the defense?
Well, first I do a self-examination. Did I fail to set certain expectations? And if I did, then I apologize and I correct the action by first correcting myself and then correcting my co-counsel. If I did set expectations, then it's a stern conversation. And I'll let them know under no circumstances this ain't going to happen again. If there's a third time, then it's a stronger conversation, and there's things that can be done. There's been occasions where we've had to take additional actions that are it's not something I care to do, but ultimately the client drives who represents them. And so I cannot fire a defense counsel, but I can talk to my client about their thoughts about them. And there's been a couple of occasions where my clients had their own thoughts and their own concerns about attorneys. I can think of one in particular where the client said, I don't particularly care for this counsel because she doesn't believe me. She's assuming I'm guilty. And in that case, I had him draft a letter, send it to the senior defense counsel that she worked for on the military side. And that senior defense counsel called me and said, do you have anything else to say? And I asked him, what do you mean? It's like, well, from your perch as a supervisory counsel, is there anything else you have to say? And I gave him my 2 cents. Um, so you hope it never gets to that point. You hope that you can mentor somebody, that they're willing to work, because litigation's work, plain and simple. But if they're not willing to work and learn, it's not going to work.
The counter on that, Joseph, let's take the flip angle. Can you share another time where a case, like the way the defense team worked together, it had a noticeable impact, especially as the case unfolded, and kind of what stood out to you from that example about the dynamics of working together?
Sure. I've had a number of really good litigation teams. And I'm fond of all of my litigation teams where we won. I have strong memories of all of those cases. But the one that I can think of that I want to speak to about this was one of my 9-victim sex assault cases that I won at Keesler Air Force Base. And in that case, I had 2 co-counsel. And I had worked with them both individually on other matters. And it just so happened that we were able to all get together and work on this particular case. And it was a monster of a case. There was a lot of litigation involved, a lot of motions practice, a lot of discovery to get through, a lot of interviews to do. And as we were going kind of through the entry level portions of it, my main co-counsel was really excited about taking on several of the motions, really excited about taking on several of the alleged victims. And when a counsel is excited to do a particular piece of the job, why would you take that away from them? Let them run with it, especially if you know that they're talented, especially if you know that they are going to put their all and their effort into it. And man, let me tell you, that particular counsel knocked it out of the park. Then I had to trade a counsel out because of assignment issues. So my third counsel came in. We had already won, I think, 2 or 3 cases together already. So he comes in and picks up right where the other one had left off as a third counsel, and just jumped in with both feet, got smart on the case, and picked. I had the majority of the alleged victims. I had picked up, crafted the cross examinations, those sorts of things. I really focused on the big picture and kind of the hardest alleged victims to cross examine and deal with. And then the other guys, I let them kind of pick and choose. Hey, what do you really? Which of these females do you want to cross-examine? Which of the parts of the case are you really interested in? And when you're interested in something, you're going to run with it and you're going to do well with it. Right. And you put your all into it. And then when you have that great working relationship, and these 2 individuals, we could joke together, and we often did. We could push back on each other. And that's a really important part of this process, the friction piece where I don't agree with you, or they don't agree with me. Okay, well, let's work that out. And I'm pretty confrontational. I'm pretty in your face. So, and I appreciate it when it comes back to me. But if someone is passive aggressive, I pick up on that too. Being a naturally confrontational person, I don't miss those cues. But thankfully, I was working with 2 hyper aggressive individuals as well. And we could push back on each other. And we could really, red team these cases and really pound out the issues and pound out. I mean, I'm not going to lie. There were several knockdown, drag out, yelling fights between the 3 of us about how we're going to resolve and solve an issue. And we all came to a consensus, and we all came to a victory for this client. We won that case. And so being able to joke, but being able to be frank, those are the key components.
So, Joseph, as we wrap on today's episode, for the listener, you just gave them some behind the scenes work there, but they've never seen some of this stuff. What would you want them to understand about how much thought goes into building the right defense team for a serious court martial?
That a lot of thought goes into it. It must be a lot of thought. They're facing federal felonies. If they're convicted, it's drastic consequences for them. So, I personally put a lot of thought into how I'm going to work with my teammate, because I have to know and trust that they're going to handle the portions of the case that they're going to handle. Not only that, but I also have to supervise what they're doing. I have to check their work. And so some counsel, it's less of that than others. So it's an assessment and a judgment call. And very rarely do I get that wrong. And when I do get it wrong in the moment, I've just taken over. And whatever their job is, I've ran with it. And that comes with preparation. You can't do that as a supervisory counsel if you're not prepared to do it. So that means what? I have to master the case.
Joseph, thank you for the time, the insights, sharing your experience. I truly appreciate it as always, my friend.
Thank you, Mike. Pleasure talking.
And thank you to everyone out there for listening to this installment of Courtroom Quarterback with attorney Joseph Jordan. If you want to learn more about Joseph's worldwide court-martial defense practice, do me a favor right now. Visit jordanucmjlaw.com. Don't forget to like, subscribe, leave a review, and comment. Share the episode with someone who needs to hear it. As always, I'm Mike Leon. We will see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.